Hello, everybody. So thank you so much for everybody joining. My name is Mark von Grundher. I'm a director of Benham and Reeves. I'm based in London. I've been working in property for 30 years, and I can honestly say this topic is a seismic change in our industry and for landlords and investors. And I'm hopefully going to dispel some of the terrifying news that's been out there trying to scare everybody, that it's going to destroy the rental market and hurt investors. So I'm going to hopefully do that. Together with me is Isabella Poe, who's based in our Hong Kong office. She looks after a lot of overseas landlords. That's one of our specialities, is looking after overseas landlords. She's going to talk a little bit at the end about what we do and where we do it. And then right at the end, we're going to do Q&A. This really shouldn't last for more than an hour. Well, I hope not. And I hope you find it interesting. By all means, ask questions. If we can't answer them, then afterwards, Isabella's details is on the end. You can email her or you can email me if you've got my details. We've already had a few pre-questions which I'm going to answer. But anyway, so let's kick off. So we're talking about something called the Renters Reform Bill. It's changing its name to the Renters' Rights Act. And it was an idea by the Conservative governments a while back to balance the tenant protections with as it says on the first slide, with fair processes for landlords. And the idea is to foster a much more stable and transparent UK rental market, of the rental market and how landlords and tenants interact. Is sweeping changes to tenancy agreements. That's the document between landlord and tenant. It effectively ends something that everybody calls ASTs in the industry. It's an assured short hold tenancy. That's the term that you rent a property from a landlord to a tenant, and it introduces something called universal assured tenancies. No longer will we have fixed term tenancies. We're going to move to something called periodic tenancies, which are aligned with rental payments. It's going to strengthen tenants' rights while imposing new compliance obligation on landlords. And the bill has passed through the House of Commons. It's currently in the House of Lords, and they're trying to tweak a bit. But let's be honest, it all goes back to the House of Commons, and they're the ones that make the final decision. So we're going to talk about the changes in a minute, but this is the thing, and it's expected to come into force the end of this year with a phased rollout. Next. So looking at the tenancy agreement, start with the key, the one before. The key structural changes that we're seeing is, as I said, no more ASTs, no more assured short tenancies. Existing and future tenancies that would have been an AST will become an assured tenancy. Now I'm going to talk a bit, but what is not an AST is a company let. So if you let your property to Sony, Mitsubishi, British Petroleum, Google, Facebook, they are not an AST. If the rent is above £100,000 a year, it is not an AST. And none of the changes that are coming into effect will affect non-ASTs. So we're going to see an end of fixed term tenancies. No more 1 year, 2 year, 3 year fixed terms. They're going to now be periodic, which, as I said, runs in alignment with the rental payments. Rent must be paid monthly. So that's a big change. No more quarterly in advance, no more 6 monthly in advance, no more 1 year in advance, no more 2 years in advance. It's only going to be month by month by month. Any tenancy terms that are contrary to the new regulations are going to be invalid. They're going to be voided. So even if you're getting the rent quarterly now, when the law comes in, the following payment, it will swap down to monthly. That's the default legal position. The next one is break clauses. So in existing ASTs, you can, as a landlord, give notice, you can have a break clause to take your property back. And equally, the tenant has a break clause. The actual break clause itself will go. There will still be mechanisms for you to get your property back for certain reasons and for the tenant to give notice. The Section 21 ban. So Section 21 is ability for a landlord to give notice to end a tenancy for any reason. It doesn't matter why. You can serve a Section 21, which is under an assured short-hold tenancy, to end the tenancy agreement. So they call those no-fault evictions. That's a lovely press word to make it all sound like very scary. But it's effectively saying you have no reason, real reason, to evict the tenant, to take your property back. They're banned under the new act. And now landlords must use something called Section 8 grounds to regain possession. That's things like non-payment of rent. There's going to be a new Schedule 2, which is going to be inserted into the Housing Act of 1988, which is the act that governs assured short-hold tenancy, specifying new grounds for possession. That's going to be if you as the landlord want to sell your property, then you're going to be able to give notice. If you want to occupy yourself, you're going to be able to give notice to the tenant for yourself or your children, because lots of our clients own for their children's education. If the tenants are antisocial in any way, or they're persistently late with their rent, then again, there's going to be new rules to get the tenant out. Another change is every landlord is going to have to register with this new private rented sector database. And you will have to have been registered with that before you obtain a possession order. Now, and the last one is there's going to be increased due diligence on our tenants. Any tenant, you've got to check them out before you let. And that's something we're recommending. Obviously, the government aren't saying that, but that's something we recommend. Rent regulation and increased rules. Well, landlords are now only going to be able to increase rent once a year. And for all of our clients who are listening, they say, well, I only did that anyway once a year. Yeah, we did. We had a 1-year fixed tenancy, and at the end, we increased the rent. But some landlords out there, they increased every 3 months or 6 months or 9 months. And this, the government thinks, is very unfair. And so it's going to be once a year. To increase the rent, you're going to still be able to increase the rent, and there's going to be no cap on the increase so long as it's in line with what the market rent is. You can't double the rent. You'll be able to put it up in line with where rents are for your type of property, your size, location, and how it's fitted out. And to give the tenant notice about the rental increase, we're going to serve a Section 13, which will require the tenant, which we've got to give them 2 months notice to increase the rent. If the tenant doesn't agree with the rental increase we're proposing, then they can take it to something called the First Tier Tribunal, FTT. They're going to be able to go there. That's going to be surveyors, and it's not going to be a law court or a judge. It's going to be people industry related who will look at the rent that you are as the landlord asking and why it should go up that much. And you will have to have very good evidence. So therefore, doing it yourself, relying on Rightmove or Zoopla, is not going to work. You're going to have a set criteria. Now, the FTT, the First Tier Tribunal, is not going to be able to say, well, Mr. Landlord, you undervalued it, so you should be getting more rent. You won't be able to get more rent. All you'll be able to get is the rent that you ask, or whatever they decide, which will be the lower of it, either the same rent or lower of that level. And landlords and tenants will still be able to agree mutually on a new rent. But we can no longer insert stepped rents into a tenants agreement. We can't say the first year the rent will be £2,000 a month, and year 2 it'll be £2,500 a month. That will no longer be allowed. That will be banned. You'll have to say 2,000, and then in a year's time, we ask for an increase. So restrictions on upfront rent and deposits. Now, this is again a big change. Landlords will no longer be able to ask for more than 1 month's rent in advance. Now, that's really important, because I would say 20% of our tenancies as a business, of the 3,500 that we run, I would say 20% have some form of upfront payment, whether they're students paying 1 year in advance or not. That will no longer be allowed. The existing deposit caps, i.e. 5 weeks rent for an assured short hold tenancy like we have now, where the rent is below £50,000, that will stay as 5 weeks rent. And above £50,000 will be 6 weeks rent. But that is the deposit. That doesn't change. But demanding in advance will not be possible. So that's why I said it's important to know who your tenant is and understand what you can do. Tenant notice periods and withdrawal rights. So tenants will be able to serve notice at any time. Okay, that's important. No more fixed 6 months or anything like that, or 1 year. The tenant can move in and then serve 2 months notice a week later. Okay, so that's a big change. Tenants can withdraw that notice before the termination date, but only if the landlord agrees. So let's say after a year, a tenant serves 2 months notice and you're like, great, I can re-let it for more money or do my works or whatever you're going to do. And then the tenant comes and says, oh, actually, I don't want to leave. I want to stay. You can reject that if you want to. Private rented sector database, I talked about that, and licensing requirements. Well, there's going to be this new database that's going to be government run. There'll be a small fee for it. The fee hasn't been declared yet. I heard anywhere from £10 to £50, but it's not been declared yet. And that'll be an annual fee, I imagine. All landlords must register themselves and their properties, not just one property. Every landlord must be registered on all their properties, and we will help with that. Everything you're seeing here, you're working with Benham and Reeves. The reason you're working with us is because I think we're the best, because we care and we want our landlords to have a good experience, and we will be here every step of the way to help you. Failure to register. If you fail to register on the landlord's database, then you won't be able to get possession. You won't be able to get your property back. So that's really important. If you're in the position where your property is in a selective licensing area, very complicated because some boroughs have it on some areas and some have it on other areas. It's all very confusing, I'm sad to say. That's why we employ 3 people internally who deal with licensing. But you must still, even with this database, get a selective license. So there was some talk around selective licensing not happening, but it's going to happen because it's money for the council, and there is no way they are going to give that up without a fight. And as I said, there'll be registration fees, which I don't know yet, even though I asked. I was at an event 3 weeks ago, and the government minister and the permanent secretary for DLUC, which is the department, did work, both there, and neither of them would commit to this or anything else, I might add. Landlord's Ombudsman Scheme. So at the moment, as an agent, we are members of an ombudsman scheme. So if anybody has a complaint against us, hopefully not, but if they do, tenant, landlord, they can take it to an ombudsman who will make a decision. Under the new law, the landlord's ombudsman scheme will be established, and a landlord must register with the private rented sector landlord ombudsman. The point is, there are a large number of landlords that don't want to use an agent, whether that's cost or they think they can do it themselves or they want to take advantage, whatever the reason might be. Well, the government don't think that's fair. There's no ombudsman to adjudicate. So now there's going to be the ombudsman designed to provide independent dispute resolution. It's going to aim also to reduce reliance on courts for tenants' complaints. You'd be amazed, because we don't have this as a business, how many tenants get no response from the landlord and they have to go to court. It clogs the courts up. So they want the ombudsman scheme to stop it. Now we're going to be here to help register you with the scheme and ensure you're compliant. Tenant protection against discrimination. Well, again, there is an awful lot of discrimination which happens in the private rented sector. I'm sad to say and embarrassed to say that it happens. But landlords now will be illegal to refuse tenants based solely that they're receiving housing benefit. Now, housing benefit is what the government give them because they may not have a job or they may not earn enough. So the government give them a top up. There are lots of landlords out there who don't want to get involved with that. Well, the government think that's ridiculous and have banned it. However, you're still going to be able to run affordability checks, and that's going to be part of the referencing process. So I get back to what we do as an agent. We reference our tenants, and you must do that. It's really important. Even if they're on housing benefit, you're entitled to know how much they're receiving and how are they going to pay the rent. The other thing is, landlords will not be able to refuse tenants who have children or who have pets unless you have a valid reason, like it's an unsuitable property. It's unsuitable size. So, if it's a one-bedroom apartment and they're a couple with 4 children, that's quite a tight squeeze, and you would be entitled to refuse on that basis. With pets, if you were going to live there and you're asthmatic or allergic to cat hair, like I am, I would reject a cat. But the point is, you have to have a valid reason and be able to prove it. Because if not, you're breaking the law by insisting on that. This is fair. Let's be honest, these are fair requirements. If you're a landlord, why do you mind if they have children or a pet? They stay longer term. Families and tenants with pets stay the longest. And if you're an investor, the longer they stay, the better it is for your property. So pets, big topic in the House of Lords, because every single member of our House of Lords seems to have 10 dogs. It's a very big topic that was debated for 12 hours. But the problem is the government aren't really taking everything under account. The landlords are no longer going to be able to unreasonably refuse a tenant with a pet. The original requirement in the Commons was going to be that tenants could be insisted on to take out pet insurance. That is at the moment a debate, and they may or may not allow that. There is a talk about allowing slightly larger deposits if they have a pet, which strikes me as very reasonable. It worked for years properly, but again, we're going to have to see what comes out. As I said, you're only going to be able to refuse a pet if you have a valid reason, like you're really allergic and can prove it via a doctor, or the superior lease. So if you're in a block of flats, which 75–80% of our clients are, and the head lease, so the $3 says no pets, then that's a reason to reject a pet. So these are the last minute amendments to the bill that are coming through between the House of Commons and the House of Lords. There's been so much talk about this topic. Labour government had a few changes to the bill. And the first one is they're going to expand local authorities' powers to actually enter a property and investigate potential licensing breaches if you don't have a selective license. Or you have an HMO, house in multiple occupation, and you haven't fulfilled all your requirements. They're going to exempt existing tenancies from the bill's restrictions on upfront payments. So if your tenancy started, let's say on the 1st of June, and you took a year in advance, and the bill comes in on the 1st of December, they're not going to make you pay your money back. That's fair. Removing the option for landlords to require pet insurance. Now, that is very much debated at the moment. It may come in, but you have to watch this space. And when we know, we'll let you know, because at the moment, as I said, we don't know. Excluding purpose-built student accommodation. Well, that's excluded, but that is only blocks of student accommodation. And they must be managed by agents signed up to a student housing code from the bill's scope. Now, that does not include a single apartment in Canary Wharf that you rent to students. That is not purpose-built student accommodation. Purpose-built student accommodation, only big blocks. Another change is going to be allowing the government to introduce later regulations permitting backdating of tribunal-approved rental increases. That may well come. Again, we don't know, but they're talking about anything that's arguing just before they may backdate that. But again, we're not sure. Clarifying that in joint tenancies, all tenants must vacate if any tenant serves notice, but allowing landlords and tenants to agree to shorten or withdraw such notices. Now, if you rent to 3 tenants and one gives notice, So they're going to clarify whether or not that means the whole tenancy ends and they all have to leave, or whether everybody has to want to leave. And so that's going to come. I imagine that they will probably go down the road. If one serves notice, all of them serve notice, which is fair, but we don't know yet. So what does this mean? I know I've been talking for 20 minutes and I've tried to keep it as short as possible and as succinct as possible because there are so much information out there. What does this mean for landlords and how are we as Benham's going to help you? Well, it's going to lead to stability and shouldn't be uncertainty. You know, the government desperately want to create clarity and long-term security for landlords as well as tenants. You know, we're moving as a country towards a European model where people rent their whole lives. Drop in first-time buyers, drop in property ownership, increase in the age of first-time buyers are all showing we are moving to much more rental model. And so they want to be fair to tenants. You know, good landlords, well, all of our clients are already compliant and we're maintaining high standards. And so we think our clients are already ahead of the curve. So you don't have to worry about compliance. You don't have to worry about those things that they will be bringing in. This is to stamp out those landlords that do not comply. And I don't know how many of you heard about that poor little girl that died from mold in her flat from a private landlord. He hadn't touched it 2 years. She was hospitalized and died. That's disgusting and should never have happened. And that's the kind of thing they want to stamp out. Reduce tenant turnover. So these stronger tenant rights will lead to longer term tenancies like they have in Germany. You can have people stay 20, 30, 40 years in a property. And as a landlord, if you're an investor, as long as you can put the rent up, which you can, why do you not want the tenant to stay long term? They treat it like it's their home. You have very low void periods, so no inter-tenancy costs, decorating and works, and they will look after it much better. A tenant who's lived in a property 10 years, it looks after it much better than someone who's been there for 6 months. So again, very important. You know, we as a business, we set ourselves up to help our clients. And Isabella's going to talk about that in a second. We do all the heavy lifting for you. We stay ahead of the legislation. I have been to so many meetings with government and with industry sources and industry leaders about this changing law. And some of the changes are because of those meetings that we had. Unfortunately, the government didn't listen to too many, but we stay ahead of the legislation so you don't have to, because there is a lot of legislation out there. We give expert compliance support. You know, we have a compliance officer. We have a team of people who are there to make sure that you comply. And I know I'm talking about compliance, which everybody thinks is deeply boring, but it's the law and you do not want to fall foul because there are big fines. And that includes inspecting the property to make sure your property stays as it should to comply. Smart investment advice. So something anybody that knows me knows they can ask me for any advice on what they're buying. And we'll help. And we're here to help you adapt your strategy of what you're buying and what you intend to do to keep yields as high as possible with the lowest possible risk. Whether that's what you're intending on buying or what you're doing with your existing property, you need help. And I think we're here to help it. And peace of mind. You know, that's one of the things that I think we offer. And especially for those clients that aren't based in the UK, who don't use our full management service, we're here to help you look after your property so you don't have to worry about it. And I think you're in safe hands. And I'm going to quickly now pass over to Isabella, who's going to run you through what we do, how we do it, how she does it for some clients. And then we're going to answer some questions. We did have a few before. I can see there are a few questions here, but we're going to try and get through. But as I said, don't feel you have to get them in now. Isabella's email is going to be at the end. And if you've got my email, you can reply on the webinar email and we'll get back to you. But I hope that was a good recap. Isabella, I'm going to pass over to you now. Thank you.
Thank you, Mark, for the very comprehensive presentation on the Renters' Right Bill. There's definitely a lot to think about, and having the right agent guiding through the purchasing and the after-sales process is very, very important with the ever-changing rules and regulations in the UK, especially if you're living overseas. Oh, sorry, next slide, please. And here's where Benham and Reeves can help. So just to briefly introduce myself, I'm Isabella from the Hong Kong office of Benham and Reeves, and we are here to help you in every step of the way and provide an end-to-end one-stop shop service for your UK properties. So we help with the whole cycle from getting the right investment advice, purchasing and acquisition of the property, checking the property prior to handover, arranging a snagging inspection, ensuring the property is handed over correctly, having the right furnishings through our sister company Install Direct, where we can arrange the right furniture package, whether you are looking to rent it out or live in the property yourself. And of course, our comprehensive letting and management service, where we would achieve the best rent and get the best tenant for you, manages on your behalf, and most importantly, making sure that you're compliant with all the UK tenancy laws and regulations. We also have our in-house tax returns team to lodge your tax returns to make it easier for our clients. And eventually, if you want to exit the market and resell your property, we can guide and help you there as well. So we provide a seamless service for our landlords and investors. So Benham and Reeves, we have 65 years of experience already in London. We have 21 London branches covering most of London and very much expanding. We have 14 international offices with presence here in Hong Kong and over 30 years of experience guiding overseas clients. Alongside, we have offices in Singapore, Shanghai, Thailand, Malaysia, Indonesia, Dubai, and many more. Also with our clients not having to worry about the time zone differences between the UK and their respective country, and speaking their own language as well with our multilingual staff. So we do have a client retention rate of 92%, which is quite high, with our clients being quite happy with our services. And we just have over 3,500 plus fully managed properties to date. So as mentioned, we do have 21 London branches and very much expanding. We're covering all parts of London, and we also have on-site offices in leading developments, working very closely with leading developers such as the Berkeley Group, Barratt's, and many more, as you can see on the map here. So if you're already a landlord and you do have property in the UK, or you're thinking about buying property in the UK or acquiring property in the UK, whether it be for investment, education for your children, or for self-use, please do not hesitate to reach out to us. We're able to help you every step of the way in ensuring to provide the utmost care and service to you. So that would conclude our presentation for this evening. We would open the floor for any Q&A now, but there has been some questions already from the audience. So I think the first question I'll kick off. So when will the Renters' Right Bill become law?
Thanks, Isabella. So that's a good question. So when will it become law? In fact, I see a few people have asked that in the Q&A chat, actually. So look, it depends when the bill will successfully pass through Parliament, and then has to go through the House of Lords, then back through the House of Commons, and then has to be signed by King Charles. It's likely to be autumn of this year. The government are very, very, very keen to get it out and done as soon as possible, but these things do take time. Determining, though, when it will actually take effect, because becoming law and taking effect are two different things. The government still hasn't confirmed because they don't know, but they have said it's going to appoint an implementation date via secondary legislation. So that will come out with the law, and then they will bring out something straight afterwards to say when it becomes effect. And on that basis, the bill is unlikely to come into effect immediately. And it's very unlikely they'll come out and say effective now. We think they'll do secondary legislation, which is what the government said. And we'll have to wait on exact live date, but it's probably going to be the end of this year.
Thank you, Mark. So for the existing landlords that we have, with the Renters' Right Act affect the existing tenancies, do landlords have to amend their existing tenancy agreements in order to comply with the bill?
Yep. Okay. That's a really good question. And I've had so many people ask me this. So When the law takes effect, so as I said, hopefully the end, should be by the end of this year, all existing ASTs, and it's really important to say that because we do have a large number of clients that do have company tenants. And if you have a company tenant, whether that's through our Japanese team, our Japan desk, or our China desk, who have company tenancies, that this doesn't affect them. Nothing changes. But when the law does take effect, all existing ASTs will convert automatically to monthly periodic tenancies. So there'll be no fixed end date, and tenancies will simply continue on a rolling basis. So you're going to have to roll with it, I'm afraid, that if your tenancy ends on the 31st of December and this law comes in on the 1st of December, you're going to roll and you will have to have a valid reason to end the tenancy. And that's whether you're selling, whether you're going to occupy, you're going to have to give notice as per the law. But we hope they're going to have some rules that allow implementation to be over a slower period as opposed to just saying on the 1st of December, but we don't know. As I said, there'll be no fixed end dates and tenancies will continue on a rolling basis. And that conversion to monthly periodic or will be at the end of the rental period. So for an example, where the rent is paid monthly on the first day of every month, if the law comes in on the middle of, say, November, then it will convert to monthly periodic on the 1st of December because you pay on the 1st of the month. If the rent is, let's say, 6 monthly and they paid the rent on the 1st of October and the law comes in on the 1st of December, it will not change. The next monthly payment will be 6 months after because they've already paid 6 months rent. And the same goes for a year's rent. As to existing tenancies and amending them to comply, we've seen no instructions on it yet. But I imagine, and they've indicated that the existing arrangements say where, as I said, the rent's paid quarterly or 6 monthly, you won't need to amend that. It will just automatically change and it will become monthly periodic. And of course, any provisions that are in existing tenancy agreements that don't comply, like rent reviews, break clauses, whatever it will become void. And so you just need to be aware, we will update you, but there's going to be nothing. There was a whole rush of people saying they were going to have to make changes and issue new documents. That's not going to come now. I think it will just run over. So there won't be anything to do.
So one of the questions that the audience asked, and it's actually one of my clients' questions as well, given the rental payments are not going to be collected in advance anymore, what is the new impact of the new bill on the student rental market requiring 6 to 12 months rent in advance? And how do international students prove their ability to pay the rent?
Okay, that's a great question. So firstly, you're actually slightly wrong in that the rent is not paid in advance. The rent is still paid in advance. It just becomes monthly in advance. So 100%, we have a large number of overseas students coming from China, the Middle East, the US, Europe, all over. These are wealthy students. And they have no credit history. They're not working. At the moment, we take rent in advance, whether that's 6 months, a year's rent. That is clearly banned. What are we going to do? You will be able to, as you are now, to insist on a guarantor. What does that mean? So at the moment, when my daughter went to university, she had no job. She needed to prove the rent. I stood as guarantor for her. I'm a UK resident. I stood as guarantor. And for UK students, parents will stand as guarantor and we will reference them and they are responsible for their child. So you are covered on the rent. If they're coming from China, for argument's sake, or the US or Europe, clearly a parental guarantor isn't going to work if they're overseas. So in that case, there are professional guarantor companies that actually do an awful lot at the moment that we are speaking to, who we will send the tenant to, or the applicant to take out a guarantor product, and they will act as the UK guarantor. So you will receive the rent monthly, but if the tenant doesn't pay, we can go to the guarantor and ask them to pay. And if they don't pay, we will obviously be able to sue them and also serve a Section 8 notice to end the tenancy for non-payment of rent. I mean, I don't know if talking around. Yeah, go on. Sorry, Isabella. Next one. You ask next
No,
question.
no. So on that topic, of not paying rent, when can a landlord regain possession if the rent is in arrears?
Yeah, that is a good question. So, as I said, it's called a Section 8 notice, part of the Act. You serve that on the tenant. At the moment, it's 2 months' notice. If the tenant is 2 months in arrears, you can serve notice right now. They are extending that to 3 months' notice. And the reason they are saying that, and I know you may or may not agree with it, but they are saying if a tenant has lost their job and fallen on hard times, we need to help them move somewhere else, or somebody needs to help them move somewhere else. So they are extending it to 3 months' notice. They have to be not 3 months' notice. They have to be 3 months in arrears on the date the notice is served. And also, crucially, they must be 3 months' notice, 3 months in arrears at the time of the hearing. That's really important. Now, this Section 8 notice will need to give the tenants 4 weeks' notice to vacate. So you will serve the notice and you will say you're 3 months in arrears. And so that's actually 2 months and 1 day because rent is monthly in advance. So it'll be 2 months and 1 day. You will serve the notice and then they have 4 weeks to vacate. If they don't vacate and they're in arrears, you would then go to court. Their tribunal will not handle, even though there's been huge drive for it, tribunal will not help with rental disputes and evictions. It will have to go to the court system. So that leads to the next question. As I said, what if the tenant does refuse to move out after, we've served a Section 8 notice on them after 4 weeks? Then, as I said, it's court, I'm afraid. It's exactly the same process as now. You ask for an order for possession, and some of the grounds for possession are mandatory. So the court has to order possession, i.e. rent arrears. It's exactly the same as we have now. The thing the government is saying, and I've heard it 3 times from the permanent secretary, that because tenancies are going to run longer and the laws are going to be much fairer, and there's going to be this new landlord ombudsman, we're going to see far fewer cases of tenants taking landlords to courts, and so therefore there'll be less pressure on the court system. Honestly, I'm not quite so convinced by that, I'm afraid. But I recommend that you follow our advice. The tenant is fully referenced. If they are overseas student, or we can't, and they're not a UK tenant with a guarantor they present, then you need a guarantor. That's what you need, or we don't want to take them. It's your risk if you take a tenant that doesn't have a guarantor. So that's number one. Number two, we have something called rental protection insurance for landlords. That is something we traditionally offered, but a lot of clients didn't take it up. We are seeing a huge uptake now on clients taking out rental protection insurance. And that protects you if the tenant doesn't pay for whatever reason, and it covers the costs of eviction. It's not terribly expensive, but it is a cost which a lot of landlords struggle with interest rates going up. But honestly, if your property's worth 3, 4, 500, 1,000 or £1,000,000, the sake of 3, 4, 500 pounds a year, for me, I put it on all of my properties, and I think it's something that we recommend. So take that out, and all the tenant has to do is they have to comply with our referencing and pass our referencing. As long as they do, you get rental insurance, which renews every year. If they are getting a guarantor, then that guarantor you shouldn't need rental insurance, but you can as a fallback take out rental insurance as well if you want to do both. I'm sure we're going to have clients that want to cover themselves, but we can do that.
There was one question here that's quite interesting. If the tenant has already paid year's rent in advance and the new bill comes into effect later this year, do we have to repay the rest of the advance rent back to the tenant?
No, absolutely not. So again, it could come out, but right now they're saying existing arrangements continue. If the tenant, as I said, and I did use the example in my talk, let's say the tenant starts now, 1st of August, they're a student coming from China, they sign a 1-year tenancy. 1st of August, they pay a year's rent to the end of July 2026. The law comes into place. Let's be nice and easy on the 1st of January 2026. So they've paid August, September, October, November, December. They've 5 months rent. They've overpaid 7 months rent till the end of July. The government is saying you can keep that rent. The new arrangement for monthly rent will start on the 1st of August 2026. So there's nothing affect to an existing upfront arrangement. The question you have is what happens in a year's time? So my advice would be you take an upfront payment and you put a rental insurance in place as a landlord, because if you have the upfront payment, then they won't be in arrears for a year. If they stay on after that and they're going to be paying monthly, then you have that rental insurance to protect yourself, because you cannot impose a guarantor on a tenant once the tenancy is rolling, is in place, because the tenant will just say no and you can't refuse them because they're already living in the property. So I think the only way is to take out rental insurance, and you can take it out retrospectively so long as the tenant is not in arrears and hasn't been in arrears, I think, for a couple of months. So again, you can take it out, and if you're interested in that, get in touch with us and we can help you do that.
So, if the landlord wants to sell the property, do they have to give notice to the tenant, and how long would the notice be?
Yeah, that's a very good question. So that is 100% coming in. And yes, if a landlord wants to sell the property, he can do. He has to give notice. So as I said, if the landlord as a landlord, you own the property as an investment. And so you buy it because you want either your children to live there or you want to make money from it. So as long as the tenant stays and pays you rent, that's a good thing, and the government appreciate that. But you wouldn't want to be an investor if you can't put the rent up, which we've explained you can. You can't give notice to the tenant, which we've explained you can, if you want to occupy, and more importantly, if you want to sell. So the law at the moment is going to be 4 months notice to the tenant if you want to sell. But you can only, if you give that notice, then you will not be able to market it for letting for 12 months. So bear that in mind. We have an awful lot of clients that say, put it on the market for sales, and we ask the tenant to leave at the end of the natural term, and we'll leave it vacant. If you have forced the tenant, if the tenant leaves of their own volition, and we market it for sales for 2-3 months, then we can market it for rental and relet it if it doesn't sell. But if you evict the tenant because you want to sell, then you can't relet it for 12 months. They are looking to reduce that period, but at the moment, it's looking like it may come down to 6 months that you can't remarket. But at the moment, it's 12 months as it's on there.
There's one more question. Can we still take a deposit from tenants? Are there any restrictions on the amount of deposit? At the moment, I believe it's 5 weeks on the deposit. Is there any
Yep.
changes there?
No change on deposits. So there's 2 types of deposits. Number one is a holding deposit. We can still take 1 week's rent as a holding deposit when they make an offer. And then that deposit gets allocated against rent when they move in. And if they withdraw and they just change their mind, then they forfeit it. There's another deposit, which is a dilapidations deposit. That's against damage or non-payment of rent. That the law sets at 5 weeks rent. If the annual rent on the property is under 50,000 a year, so about £1,000 a week. If the rent is above £50,000 a year, then it's 6 weeks rent as a deposit. If the rent is above £100,000 a year, then it's not an AST and this new law does not apply. Is that, I think
I
that's pretty much
believe that's
everything.
pretty much all the questions, because some of the
Yep.
questions in the from the audience are they repeated, and some of them you've answered already. So
Yep.
as Mark mentioned a while ago, if you have more questions, feel free to reach out to us. There is a QR code on the screen as well. You can scan the QR code or simply email the email address on the screen as well, and we'll come back to you as soon as possible.
I
So
think that's the key thing. If you have questions and you are worried, then you just get in touch with us. We will be here to guide. The law is not set yet. So lots of people are saying this is what it's going to be. I'm pretty sure most of it will be what you see at the moment. But if it changes, then we will let you know. And once we know what the law is going to be, then we'll come out and we'll send out a memo to everybody, and we'll be here to guide you through the process. But any questions, come back. This is not the disaster that a lot of people have been putting out there. It hasn't affected me as a landlord, in spite of the fact of the taxes that I have to pay as a UK resident. This really should not affect you as a landlord. If you are an overseas investor, you already paid all those taxes if you have with stamp duty to come in. Property is a long-term, fantastic investment. London and UK property has always stood the test of time. And so therefore anybody running to sell at the moment because of this change in the law, I think is madness. It's different if you want to sell for other reasons, but it's madness to sell just because of this law, because it is not going to be a bad thing. It's going to be a good thing. And within a short period of time, it will have settled down and it'll all be done. So I really wouldn't worry, and hope everybody enjoyed that. And as I said, thank you. Thanks, Isabella, for joining. Any questions? Isabella's QR code's on there. Quickly scan it before we go. I'm going to count down to 10 and then I think we're going to shut off. But we thank you very much. Any questions? You've got my email or got Isabella's email. I'm giving you 5 more seconds to scan her QR code so you can drive her nuts. But please, only property related questions, not where should you eat out in Hong Kong. These are not helpful. But these are details. We're counting down now. That was well under an hour, so I'm very impressed. Thank you very much for joining. I hope that allayed any fears anybody has. And thank you very much for spending an hour with us today. And anybody needs anything else, get in touch. Thank you very much, everybody. Thanks, Isabella.
thank you, everyone.